Hello and welcome to this next section. It's titled Use of Force Objective or Subjective. Simply put, does a career in policing carry too much risk? We've been in this territory many times before. A police officer makes a split-second decision, essentially carrying out their duty, doing what they think they've been trained to do. But fast forward weeks, months, or even years, and a different picture emerges as official bodies like the CPS or the IOPC reach very different conclusions. And this is where the problems begin. Ultimately, it seems this all comes down to subjective decisions versus objective ones. So is this more about education for officers, or does it need a different system for those investigating? Joining us on the panel for this, Steve Hartshorn, Police Federation National Board Member and Post-Incident Procedure Lead, and Scott Ingram, Criminal Defence Lawyer at Slater and Gordon. Morning to you both. There is a case at the moment. The Supreme Court will be presiding over that. We can't, for obvious reasons, talk too much about that detail or the specifics of it, but let's just get an overview about what we are referring to here. Scott, morning.
Morning, Ian. Yes, I mean, the case that's in the Supreme Court, I think, has got a major impact on policing as it arises in every occasion that a police officer uses force. So presently, unfortunately, as a result of the decision of the Court of Appeal, we now have two different tests. In criminal law, we have one test, and in police misconduct, we have a different test. So in criminal law, an officer's decision to use force will be justified based on their honestly held belief. So if they have an honest belief about the need to use force, they're not going to be guilty of any criminal offence. That's a subjective test. It's the honest belief of the officer, so a belief based on their understanding or their perception of the facts. In misconduct proceedings, now because of the Court of Appeal decision, even if an officer has an honestly held belief, they can still be dismissed if a view is taken, an objective view, that that belief was unreasonable. So most police officer decisions to use force are in quick time. Now, they're in a difficult situation, stressful scenarios. So quite how an officer is expected to be able to weigh up the criminal law test and the misconduct test before they decide to use force is really what identifies the problem here. It's far from ideal and needs to be resolved by a decision in the Supreme Court.
And Steve, I mean, you might think this is a no-brainer, that if there are no criminal action being taken, and that would have been looked at thoroughly, taking into account all the evidence and what was happening at that time, you might think that would draw a line under it.
You'd like to think so, but for me, the concern is that this decision, which is authoritative at the moment, it affects every strand of policing. It affects the frontline officers who are out there now responding to 999 calls. It affects decision makers at a senior police leadership level who may be making decisions now to put police officers out to go and execute a warrant, or maybe to conduct a surveillance exercise with support to go and arrest somebody. It might affect a chief constable who wants to affect a policing plan. And if they're making decisions now around what could potentially lead to a use of force, those decisions then start coming to this new process, and it's only right and proper that everybody involved at the front end, in the middle, at the very top, know exactly what standard they're being assessed, held to account by, because at some point they will or may have to justify that decision, either in a criminal court, and a gross misconduct hearing, or an inquest. So for us, it's about trying to get what has happened now brought to the fore so people can understand it properly, and so when they make their evidential accounts, they are writing it, recording it properly to the current standard, which is applicable to everybody.
Yeah, and I guess, Scott, knowing what that standard is, it's very difficult. You look at the case that we loosely referred to there, where you have sort of appeal upon appeal upon appeal. What one person says, okay, this is our decision, nothing to see here, everything is fine. Somebody else IOPCC come along and say, actually, we're going to challenge that. The Police Federation make their points known. That is then challenged again. And it's almost this never-ending process. And you can see why officers, and I said at the very beginning of this, is it worth the risk to even join the force at the moment? And there is that sense, I think, among police officers.
Well, I think that's right, and maybe it's unfortunate that lack of clarity arises from the wordings of the regulations and the code. I think Steve would agree that the College of Policing, when it drafted the Code of Ethics, could have been more specific about which test it wanted to apply in police misconduct, i.e. the criminal law test, the honest held belief test, or the civil test, that any belief's got to be not just honest but reasonable. And obviously it didn't make it clear, because we've got the IOPC interpreting it one way, we've got the police service interpreting it another way in terms of the training that's been delivered to officers for years. We've got the lower tier of the High Court, the Divisional Court, deciding it on the basis of the criminal test. We've got the upper tier, the Court of Appeal, deciding it on the civil test. So clearly the wording in the code is not good enough and needs to be revisited. Hopefully, if we get a judgment from the Supreme Court, that will provide sufficient impetus for the college to make the wording of the regulations and the code much clearer.
Yeah, I mean, Steve, what's a police officer? Let's take as an example a firearms incident, and an officer is in that position. There is a gun pointed at a suspect. I mean, what is that thinking supposed to be at that point? You're obviously, attempting to save lives or stop something horrific happening, and yet you're also simultaneously meant to be trying to recall various bodies' ideas of what the rules are. I mean, is that really what is expected of officers now? And it's getting more complicated, not less, it seems.
You're absolutely right, and it's a good question, because for me, when you've got a police officer who's not only a firearms officer but also intends to use any use of force, their focus point and their 100% attention should be on what they're dealing with at that time, because any use of force has got to be justified, it's got to be accounted for properly, it's got to be used in the right circumstances. So they're going through a very complex decision-making process, and the last thing they need to be thinking about now is, if I use this use of force, am I going to be criticised for something that I may have got wrong? Is it subjective? Is it objective? Where do I stand? That could cause a delay. That delay in itself may cause an injury to the officer. It might cause an injury to a member of the public. It might mean that the subject they're trying to deal with can perhaps cause further harm to other people, maybe escape. For me, it's making sure the officers know exactly where they stand. And indeed, if you look at the College of Policing, their authorised professional practice, they've got a section on risk, and it states that decisions must be judged against a standard that existed at the time, not when any review is taken place. That is still there. So for me, this needs the College of Policing now to look at what they need to be saying and training us in, to make sure we're made aware of exactly what that standard is that we are going to be held to account for. There's a bit of a saying that people don't know what they don't know. And at the moment, I would suggest, if I was to go and ask my colleagues across policing anywhere in the country, what is the standard you're held to account for? They'd probably say it's down to the criminal test, because that's what they've been trained in. And if you look at all the documents and all the paperwork that we have around that, it tends to lead towards the criminal side of having to justify use of force with honest held belief. And of course, what they do is assessed as being reasonable anyway, because clearly if they did something completely unreasonable, then it could be argued that wasn't an honest held belief. So for me, we just want clarity, we need some direction, and I want my colleagues to be able to go out there, do their job properly, focus on that job 100% to get the right result, and everyone can go home safely.
Yeah, and Scott, just explain what is, a Supreme Court ruling. You can't go beyond the Supreme Court. What happened? Does that mean that everybody else down the food chain has to take any conclusions that the Supreme Court make and draw up regulations and rules from that decision?
Yes, a Supreme Court ruling is definitely a precedent. So a decision in the Supreme Court would have to be followed in any lower courts, and also the bodies that are responsible for formulating guidance would need to take into account the view expressed by the Supreme Court. So I would say that would be a clear message to the College of Policing that it should review the wording of either the regs or the code to make sure that it's consistent with the judgment of the Supreme Court.
Yeah, and Steve, what does that mean for an individual officer then? I mean, your appeal process has run out at that stage, I guess.
for me, what it means is that the processes that officers undergo through any use of force, if it gets to the level of where this sits at potentially gross misconduct, is they've gone through what we call a post-incident procedure. So they've had the job, they've then returned to a venue, and they will have had federation support, legal support. They will have made some very comprehensive evidential accounts. That will have been given to the Independent Investigation Agency, which is currently the IOPC. It will also go to professional standards, who will make a decision in conjunction with the IOPC around any sort of misconduct or gross misconduct, and also criminal charges. So what those officers have written for them is, it was right at the time for them. They've been guided as to make sure they were adhering to those relevant standards. So it's for them to take it all forward to make sure that that process in itself can take 12 months, 2 years, 3 years. We've had some officers who've been held to account for 5, 6, 7, 8 years. So any delays now, it extends that period of time where officers are waiting to find out their future effectively. Because if it gets as far as a criminal charge, they could potentially be going to prison. They could lose their pension, they could lose their pay, they could lose their livelihood. If it goes to gross misconduct, again, their career is at risk. If they get sacked from that, then how do they pay the bills? So it's about trying to get everything dealt with properly, professionally, but as speedily as possible for the resolution for the officers, so for the family of those involved. Because take a police firearm shooting, if someone has been shot, we have to remember that there are still other people involved, that there will be family of the person that's been shot. It's only right and proper that they get to understand that process and how it's happened as well, for their peace of mind. And we're not dispassionate to that. So by making sure that things go as smooth as they can, but properly, helps to speed it up for everybody, and it stops criticisms coming forward.
Yeah, and you mentioned it, and I referenced it at the beginning, that it's a whole other debate about police being held to a different kind of account, and cases that can go on years. I think in rare cases, even over a decade. I think there's precedent for that as well. There's also an interim period here in this specific case that we referenced very loosely, in that officers are going out to work every day at the moment as we speak. There'll be police attending all manner of incidents, and that big old question mark is lurking right now.
Yeah, it is an unfortunate scenario. Up until the Court of Appeal decision on the 9th of October last year, I think everybody in the police service thought the law was pretty clear. So officers would be writing accounts on the basis, which is justifying their use of force based on what they believe to be the facts, so their honest belief. Since the 9th of October last year, they've got to consider the additional different test for misconduct. Now, they've got to be able to justify an honest belief on the basis of it being reasonable. So it's not ideal, because they've got two different things to try to wrestle with, whereas they only had one prior to the Court of Appeal decision. And that's going to remain the unfortunate scenario until we get some, hopefully, clearer guidance from the Supreme Court.
Does it surprise you, Scott, as a lawyer, when you first became aware of these kind of cases involving the police? And every time I've done debates on this with the police, most officers acknowledge that, yes, you are held to a higher level as a police officer. I don't think many people dispute that, but it does seem an extraordinary, lengthy process. And there is, I'm tempted to just use the word unfair, really, in the way that a police officer under investigation is treated incredibly differently to any other professional member of the public, and if for no other reason than the longevity of the case itself.
Yeah, I completely agree. And the IOPC's rationale for their view on this issue is that it sort of reinforces the accountability of the police. There's no doubt whatsoever that the police are accountable, and the fact that sometimes these serious cases, these top-end cases where there's a death resulting, there can be 5 to 10 years in the resolution. Now, nobody wants that sort of time frame, because it's just not fair to anybody in the process. And just going back to that accountability issue, because the IOPC's rationale is that if it's the criminal law test, i.e. an officer has to justify an action on an honestly held belief, there is no accountability for an officer, because you can't get past the officer saying I had an honest held belief. But that's completely wrong, because the assessment of an honest belief remains with the investigator, so the IOPC or the appropriate authority, when they're making the decision whether to recommend discipline or not. And also when it comes to a hearing before a misconduct panel or a meeting, it's the panel or the chair who's assessing whether the belief is honestly held. So to be honestly held, there's got to be some basis for it. So an officer asserting I had an honest belief is not of itself enough. There's got to be some basis for the belief. So if you like, there's accountability, there's an assessment by a third party of whether the belief is honestly held or not. So I just don't think the suggestion that police are unaccountable, if it's the criminal law test, stands any proper scrutiny at all.
Yeah. And Steve, just give us a taste of, you talk to officers on the ground who are involved in these kind of incidents, and every couple of years there's a high-profile incident that throws up all of these arguments. They end up, being discussed sort of outside of policing, in politics and parliament, clearly in legal circles as well. What does a rank and file Fed member make of these kind of cases? What are they thinking when they go to work? If they work in firearms, I mean, the moment you put that belt on when you go out on a job, I mean, all of this ticking over. Again, it comes back to that question as to why would anybody want to be doing this job?
You're absolutely right. And I think from sort of listening to colleagues up and down the country, there's a bit of a mixed bag. These people who are more involved in the decisions to use force, who are perhaps aware of what we're trying to say and have highlighted the difference between the subjective and the objective. But I would suggest there's a large portion of officers across the country that are completely unaware of this. Now, my concern is that shortly after the ruling last year, there was a message sent out by the NPCC, the National Police Chiefs Council, and it was sent out by Chief Constable Craig Guilford in conjunction with Chief Constable Simon Chesterman. And there was a comment in there, and it basically says that officers should be aware that for the purposes of misconduct proceedings, their use of force will be judged by reference to whether it would be objectively, i.e., by the standards of a right-thinking person with a knowledge of the facts available to the officer, be considered the necessary use of force. Now, for me, that right-thinking person, whilst it's a well-intentioned comment, I think that's quite wide-ranging, because a right-thinking person, is that a member of the public? Is it a police officer? If you gave the same set of knowledge to a member of the public that you gave to a police officer who's about to use what could potentially be a lethal use of force, would they make the same decisions? Because experience counts an awful lot. Now, if you and I were both firearms officers, you've got 15 years experience and I've got 2 days experience, your experience will probably count for a lot more than me, but we're still said to have been trained. We're both right-thinking people. So whilst I understand the comment that they've made, and it should have been circulated across the country to every single officer, I would suggest, one, that most people aren't aware of that, but two, it needs a little bit more clarity as to what a right-thinking person is, because in law, it may well be common sense. But again, if you take, for want of a better word, the footballification of politics, the people on one side, they are absolutely right, they are right-thinking in their beliefs, but on the other side, so are they. So where does it sit? And this is the kind of clarity that we need. And for me, there just needs to be absolute certainty from the people that lead us, the Home Office, the Home Secretary, the College of Policing, the National Police Chiefs Council, as to what standard we are all going to be assessed by. Because it's not just police officers as well. There's civilian employees that work in the custody suite and doing a whole variety of tasks. And if they have to use any kind of force as well, even though it might be on a lower level, if that potentially leads to an incident which makes it subjective as to whether it goes to gross misconduct or not, they're in play as well. So it affects everybody. And I think it's a really simple request, really. Tell us what the standard is, make us aware and give us some training, because that will help everybody and it will save future criticisms of the police in the future. That can only be a good thing.
Yeah, and Scott, just to sort of employ that horrible phrase, joined up thinking, but again, from an outsider's perspective on this, and from yours as a lawyer, I mean, you look at all the various parties involved in this, CPS, IOPCC, the college, the federation itself. I mean, does it need something? No two cases are the same or rarely the same. I get that, but even allowing for that, does it just not need somebody to come in and sort of bang some heads together and say, look, there clearly needs to be something that looks a little more succinct and clear. We need to have that obvious, tangible, crystal clear set of rules and regulations in place, and then we work from there. Is that what it's lacking at the moment? A better system?
Yes, I mean, I totally agree. It's a shame that we haven't got the clarity in the guidance, and I think even without this case running through the appeal structure, the relevant bodies could have got together, arguably should still get together, and thrash out what is a sensible, clear guidance on the true test. I mean, you'd have to involve the IOPC in that. It can't be just only. But I guess that's where the problem may be. It may be difficult to reach a consensus with both sides, but I still think it's potentially achievable and certainly worth doing.
Steve, where do you sense a year down the line from where we're at now? I mean, there's been so many debates on this. I can think of dozens that I've facilitated with you guys at the Federation, and each case there is that sense of, well, we've learned from this, and now next time going forward it'll be very different. And we have the IOPCC come in and they say, yes, our relationship needs to change. You've got to be more understanding of various facets and elements of each case. And then another case comes along and it seems the whole thing starts again, Steve.
You're absolutely right, and it's incredibly frustrating for us because, again, we just want that sense of direction as to where we're going to be going. It was the job of the NPCC to send out that message to chief constables, to direct that message to be cascaded down to everybody so they're aware of it. But again, there's almost a view at the highest levels, really, that, well, we can wait for the Supreme Court case. My big concern is that since that ruling became authoritative in October 2020, there was potentially a huge backlog of evidence there that is sitting waiting to be tested. We know we've got colleagues that are waiting to sit on gross misconduct hearings now, but they've been, for want of a better word, stayed until we have a Supreme Court ruling, hopefully in our favour. And my genuine belief is that other agencies are waiting for us to get across the finish line, and then they can almost go, well, that's all right, we don't need to do anything. That isn't acceptable. It's not fair on the very people it involves. And even though it might be a very small cases, because if you look at the jobs where perhaps lethal force is used or someone does die through a police intervention, those cases are very, very few and far between, but they affect so many people. So again, it's trying to make other people understand that it's not fair to sift and wait. Not fair to have to sit and wait for these decisions to be made and ratified. And again, it's fairness. It's as simple as that.
What do the IOPC say when you ask them these questions, which over the years, you'd have had these conversations? Because I don't think there's anybody who doesn't want to see swift conclusions and clear conclusions, guidelines and the like. What is, as far as you can ascertain, Steve, what is their thinking?
Good question. If you go back probably 18 months, 2 years, there was a message sent out by the then Deputy General of the IOPC, and he was kind of trying to make the point that our hands are tied. If we have to rely on an officer simply saying it's their honest held belief, then we can never, ever get across the gross misconduct hurdle. That's simply not true. As Scott's already mentioned, not only do they document their honest held belief, they document why that use of force was reasonable at that time. Now, to other people, that might not seem appropriate, but to that person who is there dealing with the threat, harm, and risk, has got all that decision-making process to go through in a split second, it's clarity. And for the IOPC to suddenly change the goalposts midway through, and they never told us they were making this change in their decision-making process until we had this particular case. It would have been nice if they consulted us properly in the first place. So look, here's what we're thinking. It could have been tested. But again, things take place in the background. We then have to pick up the pieces, and that's what led to the judicial review, so we can get absolute clarity on where we stand.
And Scott, does this ultimately have to be Do you think a political decision? Does something need to be enshrined in law to get that clarity that officers and Federation members are craving here? What needs to happen?
Well, I would hope that the Supreme Court will recognise the significance of the issue, not least by the number of parties that are all involved in the case and the length of time that this case has taken to reach the Supreme Court, and that as a consequence, the bodies responsible for producing the guidance will have to issue much more specific guidance. So it's a shame that hasn't happened up until now, but I really hope that it will happen as a result of the Supreme Court's decision, and that the IOPC and the police service will then be on the same page, whereas at the moment we're clearly not on the same page.
Yeah. Steve, I know the Federation have written to the Home Office and the Home Secretary. What kind of response are you getting? What sort of noises are being made?
So far, the responses have been fairly limited, and it is, my words, not theirs. It's a case of, well, let's wait and see what happens and where we go, because that's the process we have to follow. And again, there's that horrible opinion that because it only affects a few people, that's acceptable. That isn't acceptable. These are human beings. That they've been trained and equipped by a police service, which has been funded by the Home Office. We as police officers adhere to the law. So it's only right and proper. Those that lead us should equip us properly physically, but also educationally to deal with those challenges that we're facing. I find it wholly inappropriate that it's my colleagues that are gripping the rail, being held to account for what is others' policy. If you look at most PC, sergeants, inspectors, chief inspectors, superintendents, commanders, chief constables, they don't get involved in making the law, but we apply it, we interpret it, and we use it every single day, very successfully in the majority of cases. So we're looking to the leaders of the police service, really, the Home Office, the Home Secretary, the Policing Minister, the College of Policing, to say, come on, give us some proper guidance now, because it's only fair, it's the right thing to do. And ultimately, and I hope we are successful in our application to the Supreme Court, if we are successful, what they've done, it won't been in vain, because officers will have understood the process, they will have written their evidence to that standard. But if by chance we fail it, then officers will have been writing the correct evidence going forward. So there won't be any issues for them, because they have been trained and equipped with the right knowledge to protect themselves and justify their uses of force.
Yeah, I mean, ultimately, it's the Home Office's responsibility to train police officers. Is that, do you think, where this is likely to go? Are we looking at a complete rethinking of all of these areas in order to clear up the very issues we're discussing?
I think there'll have to be. Ultimately, the College of Policing, they are the ones that are charged with developing the trainings for everybody to adhere to. It'd be nice for the Home Office, for me and the Policing Minister, to get behind this fully now and say, come on, we don't need to delay. Let's look at some interim guidance. Let's start looking of how it might look, because, as I said, if on that Supreme Court case, if we are unsuccessful, the minute they walk out of court, everything becomes in play for use by an investigation agency. So we've got all the evidence stored up from October last year, anything that's written today, anything that's written in the future, until we get a proper decision. And for me, that causes more issues than it solves. And I think it's a simple ask. You, as a member of the public, you know now what the standard is that you have to defend yourself for. You can go and speak to a lawyer. You'll get absolute clarity. For my colleagues, we don't have that at the moment. That is manifestly unfair.
And Scott, just really a final word on this. I don't want to be too cynical about things, but I get that sort of slightly overwhelming sense that we could end up with new directives, whatever conclusions are made in court cases and the like that are ongoing. We can have Home Secretaries making a lot of noise. The Federation can make their points known. Fast forward a couple of years, do you sense from a legal perspective we might be back here discussing another nuance or issue with the new rules?
Well, it's not impossible, but on this particular issue, I think we're reaching a crucial point, and hopefully that point will be resolved so that there won't be the same sort of anomalies going forward. I mean, we've got here because of ambiguity in the wording. that ambiguity can be sorted out. So I would hope that on this particular issue, we won't have this sort of problem rumbling on beyond the Supreme Court decision.
And Steve, just a final word from you. What would you say to, we have thousands of serving officers watching this now. Many of those will be affected or have been affected in the past by these huge, troubling grey areas of law and regulation. What do you say to those members? What do you say to Federation members about where we're at and what they should be hopeful for?
The first thing I say is that if members have any concerns whatsoever, is go and speak to the local Fed reps, speak to the local Federation branch board, their chairs, their secretaries, who will have been sent communications by us about what this case means. If they then become involved in an incident where it's contentious because someone has been seriously injured or has sadly died, then it's absolutely right and proper they seek correct legal advice via the Federation so that we can get advice to them now to make sure that these considerations are catered for in such a way as to protect them, because if they don't fully understand the ramifications of what they're writing now or recording in their evidential accounts, again, it could go horribly wrong for them in the future by dint of a few words which may need to be put in. That's the right thing to do. It's the safe thing to do. And it's important that everyone has that ability to take proper advice, as would a member of the public, to do the same thing if they've been involved in something as well. So essentially, take advice, get support, and we'll do the very best to make sure you get the best legal advice going.
Okay. Steve and Scott, thank you. Steve Hartshorn is Police Federation National Board Member and Post-Incident Procedure Lead, and Scott Ingram, the Criminal Defence Lawyer from Slater and Gordon.